Hello again everyone, I'm attorney Robert Flessas and thanks for watching this video. I've made quite a few debt buyer videos and here's another one. In this video I'm going to talk about what to expect and what you should do when you go to court. In a previous video I explained who debt buyers are and that it's legal for them to purchase creditor debt. In another video I explained the basic steps that a debt buyer takes when attempting to collect the debt. In one of my more recent videos, I showed you how to read the complaint that was served on you. But first, if you like my videos, it's really important to me if you'd subscribe to my channel. Share them with your friends in the same predicament and ask them to subscribe too. If I see a good increase in my subscribers, then that tells me that you want to see more videos. And if that's the case, then I'll take the time to produce more videos for you. There's a link to my entire debt buyer playlist above me. If you click on it, you'll find more debt buyer videos that will educate you on the debt buyer lawsuit process. Well, let's get back to this video. So this is what usually happens when you go to court, and I'm going to explain to you what you do when you go to court. When you appear before your case is called, you'll want to talk to the debt buyer's attorney. Why is this important? First, by walking up to the debt buyer's attorney, that attorney is going to be disappointed because you showed up. They may not show it, but in their mind they will be. Most defendants don't show up, making that lawyer's day. That's why they're banking on no-shows. Your appearance makes their job so much harder, which they don't want. You're making them spend more time on the case. Second, the debt buyer's attorney is probably going to ask you what you want to do with the case. Sometimes they'll ask you to go out in the hallway with them so you can discuss the case. Some attorneys will briefly discuss the case right at the table where they're seated. Now don't be afraid. Make the contact with the attorney if that's possible, and it usually is. When you have the conversation, let the attorney do the talking. They're the ones suing you. Don't jump up and say yes to everything. Show no emotion. If the attorney gives you settlement terms, ask the attorney, can you do better than that? They'll look at their file, then in most cases, they'll tell you a dollar amount that represents their lowest offer. Think to yourself, though, since the debt buyer purchased the debt for pennies on the dollar, then you obviously want to settle for as low as you can negotiate. If it's low enough for you, the attorney will probably want the money in a short period of time. Unless the settlement offer is really good, don't let that attorney browbeat you into settling. Say you'll think about it. They may even try to scare you by telling you that the judge is going to find in their favor. That's not true, and it's a tactic. You're entitled under due process to have a hearing. The debt buyer has to prove their case. You don't have to prove it for them. And the attorney knows that you're a novice at this. Go back in the courtroom and wait for your case to be called. When the case is called, if the judge asks you if you owe the debt, tell the judge that without more evidence, you can't make that determination. Some people think that they need to spill the beans to the judge. You don't have to. Make it short and sweet. If you want to challenge the case, you tell the judge that. Then the court's going to set the case for a formal hearing, and the hearing that you're at now is concluded. If you worked out a settlement, then the debt buyer's attorney will tell that to the judge, and the judge will ask you to confirm that. But you should know the following before you acknowledge the settlement, because this is really important. If you and the debt buyer's attorney worked out a payment plan, the debt buyer attorney will ask the court, in the event that you don't comply with the payment plan, then the debt buyer will want to take a judgment against you for the full amount in the complaint. The same thing goes for a lump sum payment. If you fail to make the payment, the debt buyer's attorney is going to ask for the same thing, an immediate judgment against you once you default for the full amount in the complaint. They usually can take a judgment against you without any further notice to you if you fail to make a payment, and then you just wasted your time. The payment agreement and the default terms will probably be reduced to a written stipulation. That's an agreement. You and the debt buyer's attorney will sign it. Then it'll be presented to the judge for the judge's signature approving the agreement. And then when you go through all that, the case is essentially done but for your payment. In the next video, I'm going to discuss what you do if you want to challenge the case. The image that's showing next to me is the link to that video. Click on it and it'll take you right there. I'm attorney Robert Flessas. I hope you enjoyed this video. I'll see you in the next one. Take care.